The Indian government is aiming to bring about a radical change in criminal procedures by passing the Criminal Procedure Identification Bill to replace the 100-year-old Identification of Prisoners Act. When the bill was introduced in Parliament recently, it faced a lot of criticism, writes former DGP Rishiraj Singh in a column in Kerala Kaumudi's edit page. From now on, the police will have the power to collect and examine the biological samples of the convicted and arrested person. The samples include blood samples, signature handwriting, retina, iris scan, fingerprint, palm print, footprint, photograph, etc. The National Crime Records Bureau will be responsible for collecting and storing biological samples for 75 years. This information obtained by the National Crime Records Bureau can be passed on to any investigation agencies like NIA, ED, CBI, etc. Previously, biological samples could only be taken from a convicted person, that too only from a person convicted of theft or robbery. Biological samples can now be collected in any case. One does not have to be convicted for biological samples to be taken from him or her. The police have been given the right to take samples from anyone with the consent of a magistrate in support of the FIR. The consent of the accused is not even required to take the sample. When the bill was introduced in Parliament, it was criticized by opposition parties. The reason for this are as follows. According to the bill, in cases under the National Security Act and the Public Safety Act, an FIR can be prepared and samples can be collected the next day. Only the permission of the magistrate will be needed for that. This act is likely to be misused even before sentencing. It cannot be ruled out that narco analysis or brain mapping may be done by the police while taking blood samples. This is contrary to Article 23 of the Constitution. The retention of this information for up to 75 years is considered a violation of Article 21 of the Constitution. This is because it is unconstitutional for other agencies to continue to use the personal information of a person who has been convicted in a case on suspicion. The police are a matter of the state. However, the opposition alleges that with the enactment of this act, the central government will be able to interfere in the jurisdiction of the state. The police are a matter of the state. However, the opposition alleges that with the enactment of this act, the central government will be able to interfere in the jurisdiction of states. In the current scenario, when the police catch an accused, the case proceeds in two ways: questioning and inquiry. The police may have to be given some powers in cases where the criminals do not cooperate during the investigation. Action should also be taken against police officers who misuse it. Although the intent of bringing in this law is good, the potential for misuse cannot be ruled out in cases coming under the National Security Act and the Public Safety Act. The NSA Act was applied to about 2,000 people in Uttar Pradesh last year. News Desk, Kaumudy Global.